Hi friends, so I'm just sending this link to you so that you can connect me the link. So now what is the agenda today? The agenda is to discuss today's paper, that is CA Final Corporate and Allied Law November 2017 examination. So first of all, we'll see what are the weightage they have given. Now I'll just go through the weightage. The highest weightage, as we all know, directors plus meetings plus remuneration, this three package put together. Generally they used to ask 30 plus mark. This time they asked 28 marks. Then to our surprise, the next big mark is coming from auditors chapter. We never expected auditors to be like 10 marks, but as a laddu they gave us 10 marks auditors chapter, and books of accounts 4 marks they gave. To our surprise, investigation has been given a higher weightage, approximately 10 to 11 marks they have given. Then all other chapters like foreign companies, then a special court, producer company, oppression, e-governance, everything has been given weightage. What they missed to ask is winding up. See, winding up, there is one question, but it's a voluntary winding up, so it's not directly winding up. So winding up they missed. Strike off they missed. NCLT they didn't ask. NCLT they combined with IBC. Then penalties chapter. These chapters they missed. Coming to allied laws, SEBI has been given a higher weightage of 10 marks. Then FEMA 4 marks, PMLA 4 marks, Competition Act 4 marks, interpretation of statutes 4 marks, insurance 4 marks, SARFASI 4 marks. What they missed? SCRA, banking relation, IRDA. See, according to me, SCRA is almost like they are asked in every exam, but this exam they didn't ask. Okay, so the sir, how is the paper, sir? Paper is not easy. But many people told paper is easy. According to me, paper is not at all easy. More practical questions they asked. Yes, as a CA final student, they expect you to know the practical scenario. But even as a practitioner, see, I'm not just a CA practitioner, just auditing. I'm a private equity manager managing 20 plus companies of SPV, special purpose vehicle, day in and day out, handling all this IBC, NCLTs, everything, whatnot. So I noted personally for my arguments few cases. This is asked in examination, that is to my surprise. Now I'm going to discuss what are the questions they asked and my opinion on those questions. The first question they asked from disqualification, that is directors chapter. Yes, disqualification obviously is expected question because today's so many directors got disqualified under section 164 subsection 2. But the thing is, they could have asked along with 248. That will be more interesting, but they didn't ask that. So here we should write in this company where he has done the default, he is disqualified. In all other companies, also is disqualified for reappointment. So he has to vacate the office. So 164 subsection 2 should not be read alone. It should be read along with 167. Next question. Um, So in this question, whether nominee director is also affected. Nominee director will be exempted generally. Private limited company is affected. So all this thing. Next, revocation of dividend, whether it is possible. Revocation of dividend is not possible. Any percentage of the profit can be transferred to reserve. That is ultimately board's intention. That is the next question. Then third question, indebtedness question. It's a tricky question actually, but it's easy question. Auditor along with his relative is having indebtedness to a company which is in telecom industry, and auditor is also having along with his relative in another hospital industry on 3 lakh. See, industry is two different industries, so you should not add. So two different companies should not add these. So we should see in different company 5 lakh limits. Some people will be confused with business connection in this question. Please don't get confused with business connection. This question is purely on relationship. That is whether I'm having shareholding in that company. So they will be exempted. Then the next question is uh, CCI, that is competition question. In that question, it is out and out practical question. This is based on Hiranandani Hospital case. In this case, the lady will be having a previous contract with one stem cell company. She will be admitted in Hiranandani Hospital. Later, Hiranandani Hospital will come to know that she is not going to avail the stem cell services of that hospital, which is having a agreement with some some international company. So she will be like, no, no, I want to go to that service only, etc. That is the thing. But they just modified the case law in your question. In this question, they made as if there is a abusing the dominant position and there is a tie-in arrangement. That case is little different, but the case is impressed. They got influence from that case. They have asked her. They have asked this abusing dominant position case only. But in that case, it is little different. We can prove that there are no n number of companies and there is no written agreement, etc. But this case is different. But you should answer there is an abuse and dominant position and there is a tie-in agreement. Then FEMA, it's easy question only. Limits, if you want to get up to 2.5 lakh USD for studies, medicals, etc. put together, this is allowed. Beyond that, you should get RBI permission. Under liberalized remittance scheme, only 2.5 lakh USD allowed. Then in coming to the second question, woman director. See, first of all, this question is a little tricky question because it is not a listed company and it is an unlisted public company, and where the turnover is only 60 crores. So for that company, woman director itself is not needed. Then they have given one more sub question. She is director in 10 companies. Actually, the ceiling limit is already exceeded. So public limited, where she is maximum one person can hold only 20 directorships, and she is already holding 10 companies directorship. So that is another point. Then sub question of that question, they say like one person is director in 8 public companies, out of which they are director in 2 company as MD and 6 normal companies, 3 alternate directorship, 3 independent directorship. So first of all, for becoming MD, according to section 203, only one company MD. Another company, if you want to become MD, both the companies unanimous resolution has to be passed. Then 6 more companies she is doing. Then 3 alternate directorship under section 165. Alternate directorship should be included. Then 3 ID will also, that is independent directorship also included. So we should keep in mind 10 public company and 10 private company. You should keep in mind like that. So here she has crossed 10 public company. So that is my contention. Then next question is voluntary winding up along with investigation. Seriously, I don't know what question it is. So this question I am avoiding discussing. Maybe oppression mismanagement. I don't know what question it is. Voluntary winding up is not applicable for us only. So if at all they want to file a petition, they can pass special resolution under section 210. They can approach the central government. Or if they want to go to NCLT, 1/10 of the members, 100, those things. Since they mentioned special resolution, I guess it should be from 210. Then the next question is foreign company question. There is one company which is having controlled, which is a foreign company incorporated abroad, maybe Singapore, which is controlled by an Indian and Indian body corporate. So 55% is held by Indians. So under section 379, it will become all like a foreign company where the entire act is applicable. Whether they are, yes, they are having on share registers of India, so it's also considered to be a place of business. So section 2, subsection 42, place of business is there. So it's a foreign company, so controlled by Indian. So entire entire Indian Companies Act is applicable. Then the next question is SFIO question. Whether bail will be granted for the woman who is arrested under section 447 read with section 212. If public prosecutor is satisfied, bail will be granted for woman. So 3 persons who bail will be granted: woman, sick person, and juvenile. Then the next question is a Laddu question. Supplementary audit. So supplementary audit is you know, government company under section 143 they are having a right. So you have to write section 394 read with 95 read with section 143. So supplementary audit is possible by CG will be appointing. Then first auditor Laddu question. First 60 days C&AG. If they fail, additional next 30 days board. If they fail, within 60 days of the failure of the C&AG, shareholders will be appointed. 6 marks Laddu. Then the next question is IBC. This question is a very tricky question. This question is influenced from Parker Honeyfin India versus Provos International. This question, one company and another company, they come to a settlement. But the settlement they came after admission of the petition by NCLT in the case of IBC. Once the petition is admitted, it will not be withdrawn unless otherwise it is ordered by tribunal. That is the answer for this question. Then KYC norms of PMLA, how many years they should keep? Bank has to keep KYC for a period of 5 years. Even if the account is closed, they have to keep next 5 years. Then inspection, a director appointed a CA for inspecting under section 128. It's not just inspection, actually it's books of accounts. So 128, a board of directors by passing any of the director, if they get the board resolution, he can appoint agent. And whether the shareholder can appoint if they have 75%. It's a straight lifted from practice only. Shareholder cannot appoint unless otherwise they got board resolution in their favor under regulation number 89 of table F of schedule 1, or if they got the ordinary resolution from the general meeting, they can appoint. See, unless otherwise the board resolution is passed, the director cannot appoint agent. Then the next question, then they filed but it went for resubmission, whether it is rejected. No, it's not rejected, it's only resubmission. We have to rectify the mistake and do it. Generally they are allowing for 2 times resubmission. Then what is back office? I think it's they asked about a virtual office, MCA 21 portal. So what is the advantage? Easy filing, convenience, transparency, and central depository, easy inspection. This is the thing. So MCA 21 portal they are asking. Then what is blocking the transfer of shares? This question is a very tricky question. I don't know exactly what they asked, so I don't want to discuss this question. But yes, according to me, this question is maybe from operation management. So, sir, where operation from mismanagement? Section 242. Section 242, power of tribunal. In that, they can stop a transfer of any share. That may be this question. I don't know. Maybe that. Then the next question, interpretation of statutes. Whether how to interpret shall. So shall means mandatory. That is the answer for this question. Then the next question is remuneration question under section 197. First of all, you have to calculate an effective capital. Effective capital means public paid up capital plus reserves and surplus plus long-term borrowings plus debentures plus deposits minus investments. So effective capital in this question comes to negative because investment is more, plus they are also having loss. Effective capital negative means it's like a negative to 5 crores, first slab 60 lakhs. 60 lakhs means per month they should get maximum 5 lakhs, but they already getting 6 lakhs per month, so 72 lakhs. Hence, they have to pass special resolution. So up to 60 lakhs, they can just pass ordinary resolution under schedule 5. But here they are taking 72 lakhs, hence they have to pass special resolution. Then the next question, it's a SEBI question, preferential allotment. Preferential allotment for this is a tricky question because it's coming from ICDR regulation. I think 70. There is one thing. Then in that regulation number 70, preferential allotment. In that there is one mechanism called CDR, corporate debt restructuring. In that relevant date is the date for CDR. Whenever CDR package is signed, no, that is the relevant date for it. So first of all, shares should be dematerialized. Then only they can go for preferential allotment. Second, lock-in period. For others, it is 1 year. For promoters, for first 20% it is 3 years. For additional 20% it is other than 20% it's 1 year. Then who are all not entitled? That is the big question. we have to see the relevant date. Whoever is having shares before the relevant date, they are entitled. After the relevant date, not entitled. So anybody who sold the shares, they are not entitled. Who sold the shares after relevant date is entitled, before relevant date is not entitled. Then this is a tough question. Then that is the preferential share. No, it's a tough question. I cannot expect all students to write this question. Then board resolution for appointing a person for maintaining the books of accounts. It's an easy question only. Just you should draft a board resolution. Then the next question, protection of employees, section 218. See, protection of employees already asked in May 17. Again, they are asking in May 18. Again, it's from inspection chapter. Inspection chapter, they asked so many questions this time. So, protection of employees, without the approval of tribunal, the employee will not be removed by the directors. So that is the question. So that is the protection of employee allowed. So next question is mediation and conciliation committee. So mediation means, I told you this in my last video. They will ask this question because mediation and conciliation of 1996, I guess, that is the act. They introduced in the new syllabus. So I guess this question they will ask in this attempt. They asked definitely. I think section 442 is talking about this section. So mediation means interfering between two parties in the dispute, and conciliation means settling the dispute in a friendly manner. In fact, in the Act 1996, it's basically it's arbitration. So arbitration is much more legislature is included. So panel is there. Government has a panel. So we have to empanel ourselves, chartered accountant, advocates, etc. So from that they will be selecting mediation. Then the next question is what is this? I think it should be 6A, 6B question, 6B, 6B meeting. Okay, charity. Okay, charity based question. So in charity based question, it's like this: 30 plus 40 plus 50 is equal to 120 divided by 3 is equal to 40 into 5 percentage. It's equal to 2 crores. So maximum allowed amount is only 2 crores, but they have given 1.25 plus 1 is equal to 2.25 crores. So as per 181, by passing board resolution, you can give only up to 5%. Beyond that, that means in this question you have to pass ordinary resolution in the general meeting. That is the answer for this question. And the next question is member of SEBI of 60 years, they got appointed for a period of 3 years. How many more years they can be reappointed? A member can be appointed till the age 65 is over. So in this question, 60 plus 3 is equal to 63. After that, they can be reappointed for a period of 2 years. SAT, if the same question is of a tribunal, it's 68 years. So keep in mind. Then the next question, 7A. That question is a tricky question because they have given authorized capital. So many people have taken even authorized capital into the account and calculated the average. So it's 186 question. Paid up capital plus reserves is equal to 0.7 into 0.6 you should see, or only reserves, that is 0.2. So 0.7 into 0.6 is equal to 0.42, or 0.2, whichever is higher is equal to 0.42 is higher ticket. But they have given 0.5, so they have to pass special resolution. So it's like 15% of that company's investment, which is beyond my normal limit. This question, even though they've taken loan from public finance institution, it's silent on outstanding and default. So you just pass special resolution, you will not get the approval from PFI. Then the next question is again IBC. This is a very, very difficult question. You cannot even touch this question if you don't know practically. That question, one company from abroad, they filed, that is the operational trader, they filed a petition of IBC against this company in India. But there is something called certificate from the financial institution. Financial institution or bank which is referred under section 3 subsection 14 of IBC is only Indian financial institution or Indian bank. So this foreign company who cannot able to produce the proof of certificate of financial institution cannot initiate IBC against this company. This is decided in case law Marquis Bank Limited with Uttam Galva Metallics Limited, as well as this is inferred from another case law called Smart Timing Steel Limited versus National Steel and Agro India Limited. So this petition is not been admitted in this case. Then the next question is producer company. Producer company default in repayment of loan for 60 days. For 90 days, if they defaulted, then is disqualified. It's only for 60 days, so it's not disqualified. Then AGM not happened, by is not conducted AGM for due to natural calamity, no problem. Natural calamity is exempted. Then nomination facility in insurance company. A person can nominate anybody before maturing the insurance policy. So anybody can nominate. If minor is nominated, you should tell the person name to whom the money should go till the minor should become major. So these are the two things. Then SARFAESI appealing provision. This is inspired from the case law of Indian Overseas Bank versus Ashok Mills. A person can go to appeal within 45 days to DRT, and a company can initiate SARFAESI proceeding only if they proved that company becomes, the borrower becomes, that bank can initiate SARFAESI only if they prove it become NPA. So in this question, the borrower becoming NPA is silent. So we should see whether the borrower become NPA. Second, they can go for appeal also by depositing 50% of the claim, and if they want to just see extend time and all, they have to deposit 25%. And anyways, they can go to High Court also in case if they are aggrieved. So I guess any person who wrote approximately 80 marks confidently, 80 to 85 marks confidently, is very good at. If a person got 65 above, brilliant. And what average student can expect? Somewhere around 49 to 52. It is the average student's mark in this, because few questions are very straightforward question, like auditors, books, directors few question, and this dividend. So 52, 53 is easily achievable. So thanks for now. See you. Bye bye. Stay in touch with me in WhatsApp 9940512888. Bye bye.